Welcome once again to Know Your Rights University in association with Natural Essence LLC. We are back at you live again with another video that we hope will be educational, informational, and of benefit to you all. Let us begin by sharing our screen. The title of this video is called Property and Trust is Protected Against Predators and Wasteful Children. Is it true that a properly structured, irrevocable trust may protect property and assets from your children's creditors, gold digger spouses, or children with drug habits, etc.? Short answer is yes. A properly structured, irrevocable spendthrift, non-grantor, complex discretionary trust is one of the strongest asset protection structures recognized under U.S. law. When drafted correctly, it can shield trust assets from your children's creditors, divorcing spouses, predators, poor decision making, addiction issues, and other financial or legal vulnerabilities. Sometimes we think that our children are ready and may be responsible enough to take on the inheritance of our assets and property, when that may not be true in certain circumstances. Children may have drug habits. They may, be in debt and are looking to cash out of your property and not looking to preserve your property and assets, and may want to quickly sell. And, that may not have been your intent once you know, um, place your property in your children's uh, care for the preservation of your property. That sometimes children just, they may not have your vision as part of their agenda based on their desire, or maybe habits, or maybe even unforeseen things like, creditors getting into debt, or spouses that, or would be spouses that may see them as a cash cow and look to, disinherit them in some sort of way by, you know, unforeseen means. But anyway, below is the precise legal reasoning. Why these four structural elements create exceptional protection. A trust that is irrevocable, spendthrift, non-grantor, complex, and discretionary enjoys layered legal protections that work together to prevent outsiders, including creditors, from reaching trust assets. 1. Irrevocable trust removes legal ownership from the beneficiary. Once assets are transferred into an irrevocable trust, the beneficiary does not own the assets. Creditors can only reach what the beneficiary owns. Since the beneficiary has no enforceable right to demand distributions, creditors have nothing to attach. Courts cannot force the trustee to distribute assets to pay a beneficiary's debts. 2. Spendthrift clause, direct statutory protection from creditors. A valid spendthrift provision prevents the beneficiary from assigning their interests and allows the trustee to refuse access to creditors. Spendthrift clauses are enforceable in virtually all jurisdictions and creditors, excuse me, and block credit card creditors, lawsuit judgments, tort claimants, business creditors, bankruptcy trustees. Spendthrift protection applies both before and after distribution unless the trustee voluntarily chooses to distribute. 3. Non-grantor status. Trust is a separate legal entity. A non-grantor trust means the grantor does not retain control or beneficial interests. The trust itself is a separate taxpayer and separate legal owner of assets because the beneficiary did not create or fund the trust. The trust is not viewed as the beneficiary's property. Their personal creditors have no claim to trust principal. This insulates the assets from divorcing spouses, lawsuits, settlements, and judgments. 4. Discretionary trust. Beneficiary has no enforceable right to payments. If the trustee has full discretion over distributions, the beneficiary cannot force the trustee to pay them. Creditors, therefore, cannot demand or intercept any required payments. Courts across the U.S. consistently hold if the beneficiary cannot compel a distribution, neither can the beneficiary's creditor. This is the most powerful asset protection feature. 2. Who this structure protects against. It protects against children's creditors. Creditors cannot penetrate the trust or force distribution. Against divorcing spouses, gold digger spouses. In most states, discretionary trust assets are not marital property, are not subject to division and divorce, and cannot be counted as part of the child's personal estate. Children with addiction or spending problems. The trustee controls all distributions, preventing misuse of funds. So, for instance, if the trustee is on his dean and monitoring the beneficiaries as he should, then he should be able to ascertain whether or not a beneficiary is, um, in a position to adequately receive a distribution and not just blow it all frivolously on silly things such as drugs or things that may not be within the settler's intent when he created the trust. Because the parents don't know what their children may get into, what type of debts they may incur, what type of habits they may have, who they may be involved with. So these spendthrift provisions are a settler's way of protecting his valued assets and property from the hands of errant children who may not be responsible enough to carry on the settler's intent. Children with lawsuits or judgments against them. The trust is not reachable for settlement, lien, or collection. Business failures, bankruptcy, or tax issues, spendthrift, and discretionary status typically protects assets even in bankruptcy. 3. Limitations and realistic boundaries. Although extremely strong, the trust must be properly drafted. Very important. It must be properly drafted. It must be properly funded. It must be administered by an independent trustee and must not be used to defraud existing creditors. Fraudulent conveyance rules apply everywhere. Also, most states recognize exceptions for child support, rightfully so, alimony, rightfully so, and certain federal claims. Certain exception creditors varies by state. Even then, the creditor usually receives only distributions actually made, not trust principal. That is a great, great protection of the settler's assets based upon the fact that even if through the trustee's discretion he decides to distribute dividends, or money or property to any beneficiary, a creditor cannot receive the general trust property that is not distributed by the trustee to any beneficiary. So that is a great protection of trust. You know, I wish I knew about this way back when, but that's neither here nor there. But this is just to show how complete an asset protection a properly drafted, irrevocable trust is, based on the settler wishing to pass on generational wealth that can pass on from generation to generation and grow in such a way that it is protected against creditors, or beneficiaries who may incur debts. You want that protected. You don't want to have your property squandered based on children's errant ways or drug habits or, you know, in divorce court or things like that or in probate. So this is a very comprehensive way of protecting your property and assets. Four, bottom line. Yes, when properly structured, an irrevocable spendthrift, non-grantor complex discretionary trust is one of the most robust legal tools available for multi-generational wealth preservation, asset protection, protection from beneficiaries, personal vulnerabilities, divorce proofing assets, lawsuit immunity, protection from bankruptcy, and financial mismanagement. It is the same structure used by high net worth families, legacy estates, and institutional wealth planners. These huge wealthy families, they use dynasty trusts structured in this type of way to protect assets and to preserve them generation after generation after generation. Revocable trust. What about a revocable trust? Does it provide the same protection? Why revocable trusts do not provide asset protection? A revocable trust, sometimes called a living trust, is not an asset protection vehicle under U.S. law. This is true in all states and under federal legal principles. The reason is simple. If the grantor can revoke the trust, amend it, or access the assets, then the grantor is still the true owner of those assets. Below is the detailed explanation. 1. The grantor retains complete control over a revocable trust. Under a revocable trust, the grantor can amend, revoke, or terminate the trust at any time. The grantor can withdraw all assets without restriction. The grantor functions as both trust creator and often the initial trustee. Because of this control, courts and creditors treat the assets as if they are still owned by the grantor personally. Legal principle. A trust that the grantor can revoke is legally indistinguishable from the grantor's own property. Therefore, revocable trusts offer zero asset protection during the grantor's lifetime. 2. Let me back up for a second. It said during the grantor's lifetime. I believe it states that because once the grantor passes, a revocable trust comes an irrevocable trust. However, if it is not properly drafted, then it is still not properly protected, or the assets are not properly protected because any creditor may have the estate probated or may dispute whether or not the beneficiary or the grantor owes them, a debt. And then therefore, trust property, assets, money, time is wasted during the probate process. 2. Creditors can reach revocable trust assets just as easily as personal assets. In nearly every jurisdiction, if a creditor can reach the grantor's personal assets, they can reach the assets of the revocable trust. This includes judgment creditors, tort claimants, contract creditors, business creditors, bankruptcy trustees, divorce orders, which varies by state. Courts simply order the grantor to revoke the trust and pay the creditor. Why? Because the grantor retains ownership and can reach the assets. Creditors may do the same. 3. Revocable trusts provide no protection from long-term care claims or Medicaid spend down. Medicaid law treats revocable trust assets as available resources, countable assets, and fully reachable for care cost recovery. For the same reason, the grantor still controls them. 4. Estate tax law confirms the grantor still owns the assets. Because a revocable trust is fully within the grantor's control, all assets, all trust assets are included in the grantor's taxable estate under IRC sections 2036 through 2038. The IRS treats a revocable trust as a grantor trust for income tax purposes. This underscores that the law does not consider revocable trust assets to be transferred out of the grantor's estate or control in any meaningful way. 5. Spendthrift provisions do not work in revocable trusts. A spendthrift clause is legally meaningless for the grantor's own creditors if the trust is revocable. The grantor is a beneficiary, or the grantor retains control over distributions. Reason: a person cannot protect their own assets from their own creditors by putting them in a revocable trust. Courts describe this as self-settled trust doctrine. 6. Revocable trusts only avoid probate, not creditors. Revocable trusts are popular because they avoid probate, allow continuity of management, maintain privacy, and simplify administration. But avoiding probate is not asset protection. Probate avoidance does not equal asset protection. Anyone suing or collecting against the grantor during life faces no legal barrier to reaching revocable trust property. 7. When do revocable trusts convert to asset protection? Only after the grantor's death does a revocable trust become irrevocable, governed by spendthrift protection if written correctly, and see, there it is, if drafted correctly after the grantor's death, and shielded from beneficiaries' creditors. But during the grantor's lifetime, it offers zero protection. 8. Summary: why revocable trusts offer no protection. Can grantor revoke or amend the trust? A revocable trust, yes. In an irrevocable trust, no. Can the grantor access assets? In a revocable trust, yes. In an irrevocable trust, no. Are those assets available to creditors? In a revocable trust, yes, fully. In an irrevocable trust, generally, no. Are the assets removed from the estate? In a revocable trust, no. In an irrevocable trust, often yes. Does 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 it provide spendthrift protections? In a revocable trust, not for the grantor. In an irrevocable trust, yes, for beneficiaries. Does it provide long-term care protection? In a revocable trust, no. In an irrevocable trust, possibly, depends on structure. Does it provide lawsuit protection? In a revocable trust, no. In an irrevocable trust, yes, if properly drafted. Bottom line, only an irrevocable trust can provide true asset protection. Thank you once again. For more information on trust and estate planning for the protection of your property and assets, feel free to contact us at 708-539-9201 or email us at info@naturalessencellc.com. Thank you once again for tuning in. We hope and pray that this has been beneficial to you all. Peace and blessings, and until next time, thank you.